Good morning, everybody. Thank you all for joining us. We've got a few, oh, there we go. Everybody's in from the, I almost said guest room, waiting room. That was fast. All right. So we are going to go ahead and jump in and get started. And I'm going to start today like I usually do with our Zoom housekeeping instructions and reminders. I'll start by asking everybody to stay muted during the Q&A today. That just cuts down on background noise and makes it easier for everybody to hear. You are more than welcome to unmute yourself to ask a question if you would like to do that. But otherwise, if you could stay muted, that would be great. Your Zoom toolbar is probably at the bottom of your screen, depending on the kind of device that you're using. And that's where you will find your mute and unmute button, as well as your start and stop video button. You're welcome to be on camera or off, as is your comfort level. And the chat, which might be flashing for you, is the best place to submit questions or to ask us to clarify something that we've said today. As you can see from the message that I put into the chat, if we run out of time and don't get to the question that you put in the chat today, or if you think of something new that you'd like us to talk about next week, please go ahead and email it to info@condolaw.net by 4 p.m. on Monday afternoon. So that gives us a day to research and get our answers ready for you in anticipation of that week's Q&A. You can also, if you submitted a question and you weren't able to attend, or even if you just want to hear what it is that we're talking about these days, spoiler alert, it's almost always the CTA, although maybe not so much today. You can go to the link in the chat, which is for our YouTube channel, and watch recent videos. And you can also search our specific YouTube channel by keyword. And so if you search for something super common that we talk about all the time, including things like, I don't know, assessments or reserves or whatever, you might not get a small number of search results. But if you try to fine tune your language a little bit or search for combined terms, you might be able to find something that's more specific to what you're looking for. As we remind you guys every week, we are here to give general information, not to give legal advice. And so if somebody comes up to you and says, you have to do this thing, or you can't do that thing because of something that, Jennifer or me or Ken or somebody said in the Q&A, you can ignore them. This is not legal advice. The only way you can get legal advice is by consulting an attorney that has a relationship with your community association. And I guess now is as good a time as ever for my multi-times per year plug that if you don't already have an association attorney, it's a really good idea to try to get one now when you don't need one. Most law firms do not charge to set up the attorney-client relationship. It's just a matter of signing a fee agreement, getting your governing documents on record with them. And what that does is it gives you a quick alternative or quick option if you end up in a crisis, a situation where you need a lawyer to answer a certain question. Let's say you get served with a lawsuit, or an owner is saying in advance of the annual meeting that the law requires, XYZ. You have an attorney essentially on speed dial, so to speak, who you can contact, who you already have that relationship with, instead of having to scramble to get that relationship established when you are in a tight spot and need an answer quickly. The chat, like I mentioned, is for asking questions, requesting clarification, not for discussions like you sometimes see on the CAI message boards. I'm not sure if we still need to be giving that reminder, because it's been a long time since we've had anybody misbehave in the chat. So let's keep it that way. And we've also been telling you lately about the Monday Morning Minute, which is an email that goes out once a week from our Legislative Action Committee through WSCAI. And I just put a link into the chat for those of you who haven't signed up for the Monday Morning Minute yet this legislative session. If you signed up last year, you have to sign up again this year. I don't know why, but the system does not retain signups from year to year. And this is a really good way to stay informed about what's happening with the legislative session, which started on January 13th. We have a longer session this year, so it's going to go until, I feel like early April maybe. There are a lot of bills that are very, very relevant to community associations, including what they're calling a trailer bill, which is essentially a bill that's kind of attempting to clean up some of the stuff in WUCIOA that we think needs changing before it takes effect for every community in Washington state. So anyways, the Monday Morning Minute is a good way to stay informed as to what's going on. And if we ever have a particular testimony, for example, a committee hearing on a bill where we think it would be helpful for managers or homeowners or other people in the industry to testify, that's where you will see that information. So the link's in the chat. Please consider signing up for that Monday morning minute. This is the first week in a really long time where we haven't had a CTA specific question. So I'm just going to very briefly remind you all that enforcement is temporarily blocked because of a current court order. There is a lot of ongoing litigation, both in that Texas case where all those, back and forth court orders were happening over the holidays, but also in other circuits as well. And the court order that blocks enforcement could go away at any moment with no notice. And if that happens, you're going to want to have either filed or be prepared to file right away so that you're not out of compliance once enforcement comes back. So even though enforcement is temporarily blocked, we're still telling our clients that the lowest risk option is just to comply with the reporting requirement, so that you don't have to worry about keeping track of when it comes back online or what may happen with all that litigation. The last thing that I want to cover as far as housekeeping or sort of general announcements goes is we had questions that were submitted this week that we are just not going to answer, or that we're going to rephrase and try to simplify quite a bit. And the reason for that is because they were either incredibly specific, which this is not the venue in which to get answers like that, questions like that answered, or they were really repetitive of previous questions. And that language is more diplomatic than I am. I'm just going to be blunt and say we are starting to get repeat questions that are very clearly just changing the question enough that they're trying to get us to give a different answer to something that we've said in this Q&A before. And I think we've mentioned this, every now and then in the past. If you don't like the answer that we're giving you, that's okay. We're not giving you legal advice. If you need legal advice for your specific community in a particular situation, that's where you go ask your attorney for advice. We're also not judges. And what we are doing here is looking at the language of these statutes and the questions that you all submit to us and telling you what we think the answer to that question is based on, number one, the plain language of the statute whenever possible, and number two, the legislative intent behind the statute in question. Because those are the things that courts look at when interpreting these questions, as they get included in lawsuits and come before courts. But we aren't judges. We are not infallible. And at the same time, we're not going to change our answer because you don't like it. Also, the legislature sometimes does stuff that we don't like. I mean, the CTA is a perfect example of that, right? It is a federal statute that had a very certainly valuable goal in terms of addressing issues around terrorism and money laundering, right? But sort of as an unintended consequence of that, all of these community associations now have to report when money laundering and terrorism are not generally problems in community associations. By the same token, you might not like that WUCIOA is going to be the last bill standing in Washington state pretty soon, and it's going to eliminate all of the pre-existing statutes, and everybody is going to have to comply with things like, open board meetings and whatever else. I don't know what to tell you because none of us controls the legislature. So if you find yourself rewriting and reworking and tweaking and like parsing a comma in a statute, trying to get a different answer to a question that we've answered a half a dozen times before, I might suggest that you put that energy into writing some emails and letters to your legislators, rather than trying to get us to give you a different answer. We're not the end all be all authority on this stuff. We're just giving you our best, most educated answers. And some of the times you're not going to like those answers. And, spoiler alert, some of the times a really big part of our job is telling our clients things they don't want to hear either. So it's not that we enjoy giving you the answers that you don't want, but we're always going to try to be as accurate and make our best guess as to how a court might interpret things. So to the extent that we keep getting questions like that are sort of reworked just enough to try to get a different answer out of us on certain topics, we're just not going to keep taking those questions. And so we're putting everybody on notice of that. And I don't think I need to say anything further. So unless Jennifer, you have anything to add, I'm going to jump into the questions. No,
I'm good.
All right. So here's our first question for today. Is it true that WUCIOA associations are required to have open ARC meetings? ARC is an architectural review committee, and that ARC votes can only be done at those meetings and can never be done electronically? If so, what law states that? My understanding was that electronic votes were acceptable as long as that vote gets ratified at the next meeting. Is that not the case for these associations? So the short version is this. It is true that most committees in WUCIOA communities are required to hold open meetings and to vote at those open meetings. The statute in question is RCW 6490-445, subsection 2. And that subsection of the statute applies to all board meetings and committee meetings when those committees exercise the power of the board. So those committees, such committees must hold open meetings just like boards are required to do, and they must make all substantive decisions at those open meetings, not electronically and not in executive session. The statute specifically says that. If a committee is advisory only, the answer to the question might be different. I'd have to look at the specific composition of the committee and determine whether it's being called advisory only to avoid the open meeting requirement. But if the committee is, as often ARCs are, a committee that actually makes decisions on behalf of the board, then it's subject to all the same open meeting requirements and voting requirements as the board. And that's by statute. And this has been true since WUCIOA was adopted or enacted in 2018. So from its inception, WUCIOA limited boards from making decisions outside of open board meetings. There is a very tiny subset of decisions boards can make outside of board meetings. Those include ministerial decisions or decisions essentially confirming something they've already decided at an open board meeting. Any new substantive decision made by a board or by a committee exercising the power of the board in a WUCIOA community must be made at an open meeting. Non-WUCIOA communities are not yet bound by these limitations. However, I know we've been talking a lot about the WUCIOA for all date being January 1 of 2028, and I want to put everybody on notice here that there is a bill being considered by the legislature this session that would make these particular sections of WUCIOA applicable to everybody January 1 of 2026. And that bill is likely to pass. So open board meetings, open committee meetings, no longer being able to vote by email, all of these things are highly likely to be applicable to everyone January 1 of 2026. So WUCIOA communities you're supposed to be operating like this already and have been supposed to operate like this since the statute was adopted in 2018. Everybody else, you might not currently have an open board meeting requirement. You might currently be able to vote on things unanimously in writing outside of a board meeting, but that ability is very likely to go away come January 1, 2026. So one of the things that we're telling all of our clients and that we have repeated many times in this Q&A is start shifting the way that you do business towards the WUCIOA way, because if you make that shift gradually over time, it's going to feel a lot less painful and your mistakes will be a lot less costly than if you wait until the last minute, fail to make the shift as required, or screw up in a really big way as you're kind of working out those kinks once it is a legal requirement rather than a recommendation, to move in that direction. Jen, did you want to add anything to that?
No, I think you covered it.
Okay.
Our next question. A common topic is that votes cannot be taken during executive session, and a meeting is a meeting is a meeting. There's a great deal of work and discussion that occurs between regularly scheduled and executive meetings that does not require a vote. So this is more of a statement, but we're going to address it anyway. Information can be gathered and presented to board members before board meetings. Discussion and voting must happen in an open meeting. So just as Valerie said a couple seconds ago, the legislature is really cutting down and extremely tired of complaints by owners and other people in the industry about boards making decisions and doing discussions in private settings outside of open meetings. So individual board members are able to do work for the association and do projects under delegated authority by the board, but discussion votes must happen in open meetings. So next part of this question, for 6434 through 75 sub 2 sub B, this refers to meeting minutes. It appears that a board is allowed to take action without there being a meeting. So continuing with this question, does this refer only to votes made electronically, or does that imply the board can meet informally? Again, votes and discussion must happen in open meetings. If board members are meeting informally to discuss association business, it's a meeting. The statutory citation and the statute that this individual gave was incorrect. I believe it's 6434 372 sub 3 sub B. But the best practice and what the legislature and the clear legislative intent behind these statutes is that votes must happen at an open meeting and not outside of regularly scheduled meetings. Right now, condominiums are not required to hold open meetings, but as Valerie said, the legislature is looking at a bill that changes that, and that bill is likely to pass. So as Valerie said, get into the habit now of following WUCIOA, following these provisions, so you don't have a challenge later.
Hey, Jen, do you mind if I jump in with a sidebar on this?
Go ahead.
One of the things that I was just thinking about as you were talking about the statute is that the question was written in a way that suggests that it's a sort of a best practice. It's fine for the board to make a whole bunch of decisions outside of a board meeting because there is essentially statutory cover for that, the unanimous written consent outside of a meeting thing. And I would like to point out that the fact that the legislature at some point decided that that was a reasonable alternative to making a decision at a board meeting does not mean the legislature thought that was how you would make the majority of your decisions, right? The unanimous written consent outside of a board meeting exception is just that, it's an exception. It was never contemplated that that would essentially replace discussion and decision-making at a board meeting. It was, here's a reasonable exception to this rule to allow you to handle business in between board meetings, not a here, do this instead of having board meetings where you conduct all of your business as corporations do. So I think it's worth pointing that out.
Just as in a nutshell, why are you wanting to continue a practice that the legislature has shown over and over again that it is not behind and it is not recommended? And I'm going to address something in the chat really quick. Somebody asked about associations can't approve fixing a roof leak without an open meeting or repainting a house the same color. If there is an actual emergency, getting approval to bring someone in to fix a leak, that generally is okay. Painting a house the same color can wait 2, 3, 4 weeks until there's a meeting. The boards and managers have gotten into a habit of wanting to respond immediately and get these votes done, just get everything done and do it behind closed doors. That's not the legislative intent. And that's going to start bringing liability starting, as Valerie said, January 1st, 2026, when and if this bill passes to make the open meeting requirements applicable to everyone. So back to the prepared questions. Can you cite to a section of 6434 that states votes cannot be made during the executive session? So again, 6434 and 6432 do not have the open meeting requirement. That may change this year if the legislature passes that particular bill. So best practice is to follow the open meeting requirements of 6490 because that will be applicable to all, either starting January 1st, 2028 or January 1st, 2026, depending on how the legislative session goes. So the last part of this question, can you cite to a section of 6434 that says the same thing as 6490-445? So 6490-445 is the committee and open meetings, and there is none in 6434. It's the new Condominium Act that came into effect July 1st of 1990. So as we've said before, right now, condominiums don't have the same open meeting requirements as HOAs and WUCIOA communities. However, that's probably going to change because the legislature has heard too many stories of boards doing things behind closed doors, and they're making this applicable to everyone. Valerie, did you have anything to add?
I do not. The next question is this. We have a few questions as we move toward WUCIOA for all. Is there a limitation or drop dead date in advance of annual meetings to say we can't accept ballots past a certain date, like 2 weeks prior to the meeting? So I think we had a little bit of confusion about this question, because if you're voting at the meeting and not voting by mail, then those are two different methods of voting, right? And if you're using absentee ballots which are provided for by all of the governing statutes, we would expect that any ballots received prior to the start of the meeting would be counted. So I'm not really sure why you would cut off ballots 2 weeks before the meeting. I think we've got clients that maybe would set a deadline of a couple hours before the meeting, or they have to arrive the day before the meeting. Those might be reasonable, but I think 2 weeks before the meeting is probably unreasonable. If you're voting by mail, there is a specific process that is set forth in all of the statutes. If you Google your governing statute, say RCW 6434, because you're a Condo Act community, if you Google that plus voting, then you can see what the statute lays out as the process that you must follow in order to vote by mail. And in that particular process, there would be a specific date upon which the votes would be counted. Then you determine if a quorum is met and what the results would be. So as the voting statutes stand, owners can vote at a meeting or by ballot at a meeting that includes voting in person, by proxy, or absentee ballot. The association can require that they be submitted before the meeting, but probably not 2 weeks in advance. I think that's an unreasonable length of time. Also, how far in advance are you sending out notice of the meeting, right? And it also probably depends on other things too that aren't even in our question notes. Are you accepting nominations from the floor for the board election? How are you going to handle that if you're trying to get people to turn in the ballots 2 weeks before, right? So it depends a lot on what you're doing at the meeting, what amount of notice you gave for the meeting, what did your governing documents say? Sometimes there's language in the governing documents about voting, so you want to make sure that you're complying with that as well. And then again, also, if you're having additional voting by mail outside of the meeting, you want to make sure that you're following the statutory requirements for that. So I think it's reasonable to have a deadline previous to the start of the meeting. I think 2 weeks is too long. Most of our clients just say that the ballots have to be received before the meeting starts or by the start of the meeting. Because also sometimes people will actually show up in person and try to hand you their ballot. That ballot should be counted too, even if it's not received until the start of the meeting. So there's a second part to this question, which says, if we have a hybrid meeting, can we say that the election results will be available tomorrow, like 1 or 2 days after the annual meeting, or do they have to be made available during the meeting? And again, there's no statutory requirement here, but the best practice is to tabulate the votes at the meeting so that the results can be announced by the end of the meeting. And the primary reason for this is that it reduces opportunities for people to sort of create conspiracy theories in their minds. If you're voting at the meeting, but you don't count the votes at the meeting, and if somebody doesn't like the results, the fact that you didn't count the votes at the meeting gives them a little bit of a toehold to argue that there's something bad about the vote tabulation process. And so just counting the votes at the meeting and announcing them by the end of the meeting. You can have, for example, if you have a small committee that is tabulating the results of the vote, they can be working on tabulating the results of the vote while the board is conducting the rest of the meeting, maybe during the owner forum, reports to the community, whatever, and then announce those at the end of the meeting, so that you are not giving the conspiracy theorists in your community a toehold to make an argument that something shady is going on with the way the votes are being counted. And again, as I mentioned just before, in the first part of this question, if you want to combine mailed votes with those that were cast in person, you have to plan in advance for that. And you want to, again, look at the statutory requirement for voting by mail to make sure that you follow this process that's outlined in the statute for that. And if you've been coming to this Q&A for any length of time, you will have heard one of us say this before, which is process matters and is also the single biggest way that owners are able to successfully challenge association actions. It's usually not because the substance of the decision or the action was successfully challenged. It's usually because somebody messed up the procedure. So that's why I keep pointing you back to that statute. If you're going to be conducting voting by mail, you want to make sure you understand the steps that are required and follow those steps so that your process is not subject to successful challenge. Jennifer, did you have anything you wanted to add?
I don't. So the next question is another long one.
You want me, I'm going to interrupt. Can I boil the question down instead of reading the whole dang thing, which is too long?
Yeah, I was definitely going to boil down the first part. So if you want to go ahead, I can.
Okay.
Already have the answer prepared.
So this question is about the requirement to record board votes taken during a meeting of unit owners and boards. Is a vote an action? That's part one of the question.
So the answer to that is yes. And I'm just going to recite some statutes off the top of my head. 6434-308 sub 1, which is also applicable to Old Act condos. 6438-025, I believe, sub 1. And I don't remember 6490 off the top of my head. But those particular statutes state that the association acts through the board of directors. And then if you look in the nonprofit corporations statutes, the action of the board is by a vote of a quorum present at a meeting. So all of this boiled down is the action of the association and the action of the board is by voting. So this particular individual was asking for specific legal advice or a specific answer to the question, and we can't do that here. But every action taken by a board must be recorded. And we don't understand why a board or someone would not record a vote taken by a board at a meeting. So next part of the question, and Valerie, did you want to condense that, or is this one okay?
I think this one's okay. It's short enough.
Okay. So owners rely on the record. If the action is not recorded, did it occur? A vote can have serious consequences. And Ken stated in a podcast he spends time trying to get boards out of trouble for not following procedure. We've pretty much covered this a little bit already, but best evidence of an association action and a board action is by board meeting minutes or annual meeting minutes. If an action was not recorded, and we have this come up when somebody does something and people believe that the board approved it at some time, but it wasn't reflected in board meeting minutes, but there's some sort of history there. So if the other extrinsic evidence may be used, but it's harder to determine and use for future questions. And it's easier for owners to challenge when you have this historical practice, but there's no basis for it. This has come up before quite a bit in our Q&As. If it's not written down, it didn't happen. So actions, votes taken at a meeting must be recorded in board meeting minutes. The record of the association action is in the minutes. And then last part of this question, once the meeting minutes are made available to owners by way of their posting in association records, the board is this proper notice? Even if a proper notice is transmitted, is it applicable? It is applicable the moment it is sent by email or mailed. Mail delivery takes time, which can have serious financial consequences for an owner. How is an owner protected? So meeting minutes aren't a record that requires formal notice. None of the statutes require that. Meeting minutes are a record owners are entitled to have or entitled to receive, but it doesn't require formal notice of mailing or emailing as listed in the statutes. Some actions by a board may require notice to owners, such as adoption of new rules, adopting a fine schedule, etc. But the actual meeting minutes themselves do not require formal notice. Things that require formal notice are listed either in the statutes or listed in the governing documents. So there's a citation 6490-445 sub 2 sub n. Even if an action by the board is not in compliance with this section, meaning the open meeting requirements. Thanks, Valerie. And Valerie put the language in the chat. So an owner can challenge a board action within 90 days of receiving notice of that particular action, but the notice is when the meeting minutes are distributed. So the record of an action might be in a copy of the meeting minutes, or it might be a letter or some other notice. Owners can opt into receiving electronic notices. So then the onus is on you to seek out that information, or you can ask that the board or the manager specifically email you meeting minutes. They may or may not do that. It's not required, but you can ask. You can ask to have meeting minutes posted on a website. So formal notice is not required for board or association meeting minutes. That's all that this boils down to. Valerie, did you have anything to add to that?
The one thing I would like to add is, again, this is in WUCIOA only right now, but also, again, this is likely to be applicable to everybody in January of next year based on this legislative session. The safe harbor language that I just posted into the chat, which essentially says that a board action is not subject to challenge any more than 90 days after notice of that action is distributed to the unit owners. That is one argument in favor of going ahead and distributing your board meeting minutes to all of your owners each month as they are approved, right? So if you meet once a month and you have your January board meeting and you draft minutes, and then at the February meeting, those minutes are approved by the board, I don't think it's a bad idea to consider mailing those minutes to all of your owners in February once they're approved. In particular, if you're a WUCIOA community or everybody once we're governed by this part of the statute, because that is giving your owners notice of every board action that was taken at that board meeting. And that starts the clock ticking on the 90-day window during which an owner can challenge that board action. And once the 90 days after that notice is given has passed, the likelihood of a successful owner challenge of a particular board action taken at that meeting, the likelihood of success plummets because of this essential safe harbor language in the statute. So that's something that you might want to consider if you are a WUCIOA community. This is something you could consider right now. if you're not yet a WUCIOA community, this is something you could consider once this provision of the statute becomes applicable to you. And I do want to note, though, that as Jennifer said, you want the way that you give notice of the board actions taken at this board meeting is that you have to give notice in a manner that's consistent with the statutes. So posting it on the association website is a great idea when it comes to transparency and just giving owners information, right? Making that information available. I'm not sure that that would satisfy the notice requirement for the purpose of starting the 90-day clock ticking on this safe harbor language. I think in order to do that, you would probably have to send the meeting minutes to each owner in whatever method they have agreed to accept notices from the association. So if people have opted into electronic notice, emailing it to them is fine. If they haven't, you might need to put it in the mail to them if you're trying to take advantage of this language. All right, I'm going to move us to the next question. Where can I look to find current laws regarding condominiums wanting to limit the size of dog allowed in the community? So there is not a specific statute that speaks to this particular issue, but the ability to own or keep a pet is often considered a use of the unit, and most restrictions on use are required to be in the declaration in order to be enforceable. If only it were that cut and dry, we could just stop there, right? But it's not, because of a few things. Sometimes a declaration will have language in it that says owners may keep domesticated animals subject to reasonable rules and regulations adopted by the board. So in that scenario, it might be possible to restrict the size of the dog that an owner is allowed to keep, or the number of dogs that an owner is allowed to keep. There's also general rulemaking authority in all of the governing statutes for community associations in Washington state, and says that boards may adopt reasonable rules and regulations within their community. And so part of the question, and it's a gray area, right, is whether that general rulemaking authority allows a board to say the maximum weight for a pet in our community is 30 pounds. And there's no cut and dry answer to this question, because it probably depends a lot on your specific community. If you're a single family home HOA with quarter-acre lots and you're trying to say nobody's allowed to have a dog larger than 30 pounds in their house, I'm going to probably suggest that that's not reasonable. Whereas if you are a high-rise condominium of micro units in downtown Seattle and they're 500 square feet or smaller, it might be entirely reasonable to say that the maximum size pet allowed is 30 pounds, right? So it depends on the circumstances. It also probably depends on what the intent behind the rule is. Are you trying to limit future problems, or are you trying to target an animal that's in your community right now that you want gone? The answers to those two questions as to whether it's reasonable and whether you should adopt a rule like that would be very different. So all other things being equal, though, for the most part, our recommendation to clients is that rather than restrict breeds or size-based restrictions, adopt rules that govern the behavior and the impact that animals can have on the community as a whole. For example, a 60-pound golden retriever is probably going to be way more chill and way less disruptive than most 10-pound chihuahuas. No offense to the chihuahua lovers in the group, right? So banning dogs over 30 pounds or over 50 pounds isn't going to address the 10-pound ankle biter that's nipping people and barking all the time or whatever. Similarly, although in a somewhat different vein, a rule, for example, that talks about like the noise that your pets can make, or the obligation that owners have to pick up after their pets in the common areas, as an example, that's something that you could enforce regardless of the size or breed of the animal in question. So regulate the behavior and their impact within the community rather than the size or the breed. Jen, did you have anything you wanted to add to that?
Just briefly, when this question comes up with our clients, and we do get asked this as legal advice, one of the things we typically ask is the board going to go around with a scale and weigh every dog that they see? That, and as dogs get older, same as humans, they may start adding a little extra weight. Are you going to make an owner and enforce this particular rule against an owner whose pet is now 8, 10, 12 years old and is a couple pounds overweight when previously they were under. So it all comes down to being reasonable. And it's usually easier to regulate behavior rather than weight. So moving on to the next question. If reserves are invested which then produces income, would statutes require that such income be retained as reserves, notwithstanding the rules for borrowing reserve funds? Can you provide a citation? So I'm not sure where borrowing reserve funds, that particular part of the question, comes from. Borrowing reserve funds is actually when you take money out of reserves for a project that may or may not be in your reserve study. So the answer to this question has been covered pretty thoroughly back in November and December when people were doing budget questions. So you may want to go back and take a look at those. Statute doesn't really address this, but generally income is income and would be added to the reserve contribution or used as general funds. So income only becomes reserves when it's transferred at the direction of the board. So reserve professionals will assume income from reserve investments are reserve funds, but it requires the accounting part or the accounting transfer by the board. So Valerie, did you have anything to add to that?
The only other suggestion I can make is that you can certainly ask your accountant whether there is an advantage to treating that income one way or another. But legally, I think what it boils down to is the board gets to make the decision, and there isn't a statutory requirement that it be treated one way or the other. So our next question is about resale certificates, and it's actually kind of a long question, but I'm just going to paraphrase it. The question essentially says that there's a $275 fee that associations are limited to charging when providing a resale certificate to a seller when they're selling their property. But there are often follow-up questions to the board from either the seller or the buyer. And the question asks two things. Can you charge the seller or the buyer for that added work after you've provided the required resale certificate? And what should you do if they're asking the board or community manager to interpret the resale certificate or disclosures for them? So all of the governing statutes for resale certificates, I'm going to go ahead and copy and paste them into the chat. And I will remind everybody that, again, even if you are currently in an HOA, for example, that does not have a resale certificate requirement, you will soon because of the impending WUCIOA for all. And the fee is a maximum. The $275 fee set by the statute is a maximum, and it essentially, the statutes require a set of disclosures and documents be provided as part of the resale certificate to the person who is selling their property, and then they have the obligation to provide it to the buyer. If the seller, who is an owner in your community, is asking for a bunch of additional records that are not required as part of the resale certificate, then you treat that like a records request from an owner, from any other owner. And if there are costs associated with providing those records to the owner, to the seller, then I would definitely recommend you communicate those costs or estimated costs to them ahead of time and get them to agree to pay whatever that fee is. So let's say it requires your management company to spend, 3 hours going through bankers' boxes of old association records, and they charge you $100 an hour for that time. So you want to be able to charge the owner $100 an hour for that time. Tell them about ahead of time, get them to agree to the cost so that it is not a dispute or an argument that you're trying to have after the fact. If the buyer comes to you asking for a bunch of stuff, they don't currently have any relationship with the association, and you're not obligated to give them additional records. You can certainly direct them to the seller with any of their questions. And in particular, if they're asking you to interpret the resale certificate, the disclosures that are made therein, can you tell me what does this mean in your declaration or whatever? I think that you are not obligated to answer those questions. And not only are you not obligated, again, this is assuming you've provided a complete resale certificate as the statutes require. I think not only are you not obligated, if you answer a bunch of questions requesting interpretation of the documents, you are potentially exposing the association to some liability, because let's say you interpret something one way and they buy the unit or lot relying on that interpretation, and then it turns out you were wrong. That could create a risk of liability for the association. So when it comes to providing what's required by the statute, absolutely do that all 100%, obviously. When it comes to interpretation beyond that point, I would respond to a purchaser asking those types of questions and say the association can't answer these questions for you. You are welcome to consult with your own attorney who can help you interpret the documents and answer the questions that you have. And when it comes to a records request from the current owner, seller, remember that owners have the right to review records in the manner in which they are kept by the association in the normal course of business. The association is not required to produce records it doesn't have, to synthesize information in the specific way that the owner has requested that you do so, or to compile documents that are not otherwise compiled in a certain way. The flip side of that coin is sometimes it's easier just to do it, right? Because sometimes it takes 30 minutes to go through records and compile what they're asking for and email it to them, versus 4 hours to have them come in and make an appointment and look through boxes and then make copies. And so, I think using the association isn't obligated to synthesize or compile records to make an owner's life more difficult when what they're asking for is relatively straightforward and reasonable. I don't want our clients to do that. I wouldn't suggest that you guys do that. But the statute does provide that protection for an association if an owner is asking for a ridiculous amount of records, or for them to be produced in a certain way that would require a huge investment of time by the association. That is not something you're obligated to do. Jen, did you have anything you wanted to add to that one?
No, I just added to the chat the statutory citations for the reference about compiling or synthesizing information.
Perfect.
So our next question, who would be responsible for repairing damage inside a condominium unit caused by a leaking window, the association or the unit owner? Is unit damage caused by a window leak handled differently than unit damage caused by, say, a roof leak? So we can't answer this question. The reason being is that the answers depend on very specific language in the governing documents regarding damage and insurance, as well as specific details regarding where the damage occurred, what was damaged, and there are too many variables for us to answer, because honestly, we've had condominium A with a leak from, say, a roof or a window, and the answer was one way, and then condominium B had a similar situation, similar circumstances, but the language in the declaration was different, so they received a different answer. It really depends on the governing documents. So most condominium documents have a specific section regarding damage and destruction. And this is for damage regardless of what caused the damage. This is what controls. A lot of times we get condominiums or other condominium associations relying on the maintenance provisions. So if owners are required to maintain, repair, replace, say, a hot water heater, then the association assumes that the owners are also responsible to repair damage caused by that particular component, which may not be the case. When there is damage, the specific section on damage controls. So some declarations treat damage caused by an owner's misconduct differently than other kinds of damage. That depends on the language in your governing documents. You cannot rely on practices that have happened before, when prior boards or association managers didn't take a look at the entire document and got the wrong answer. We have had many clients come to us. Valerie sees it all the time, honestly, in collections, where the association has tried to shift a cost of damage to a particular owner when there's no authority for that shifting in the governing documents. And then we have to tell the board that, I'm sorry, this is not collectible. And they get really upset with us because that's not the answer that they wanted, but that's how the documents read. Valerie, did you have anything to add to that?
Yeah, just quickly, it might surprise you all to know that whenever we get a question from a client of, can we charge the owner for X, whatever the thing is, there's not just one, not two, not three, not four, but at least 5, sometimes 6 different sections of the declaration that we look at to determine who is responsible for whatever the thing is that the client is asking about. Also, sometimes the same client will come to us with 2 different scenarios that are maybe sort of similar, but maybe the cause is different. And they'll get completely different answers for those 2 scenarios with the same governing documents. So you can't rely on, let's say you got a memo from your attorney 5 years ago when somebody's window leaked because of, I don't know, the seal broke or something. You can't then take that memo and rely on it in perpetuity for every leak that ever happens in your community after that, because often the answer will be different based on the specific circumstances. So it's a more complex question than anybody realizes when they ask. So you have to ask your association attorney. I'm going to try to motor through a couple more questions here because I can't believe we're almost 10 minutes. All right, we can do it. For self-managed associations seeking to outsource some operations to alleviate some headache for the board, what essential functions or services would you recommend they outsource for optimum efficiency and protection? So I don't know about protection per se, but I'll tell you that you can hire a management company for sometimes as little or as much assistance as you want. We do know that there are management companies out there that will do financials only. That's generally sort of like the baseline. And we obviously work with management companies that do everything between that and the whole enchilada, full service management, managing insurance claims, all kinds of things. I think as a starting point, and it also probably depends on the size of your community, but the financial only thing seems like a really good place to start to me, because what that does is it allows your board still oversees the financials, right? From like the big picture and the decision making, but you have assistance with the day-to-day financial operations of the community, like receiving assessment payments, sending delinquent notices, paying bills, that kind of thing. Preparation of financial statements, monthly, quarterly, etc. Some of the things that tend to take a lot of time when they happen would include when there are insurance related damage events. And a lot of management companies will have somebody available at an extra charge to help you manage that process when it occurs. We would also generally recommend you work with your insurance professional and also potentially consult with your association attorney whenever you have that kind of damage event, just to make sure that you understand the project and the obligations of the association when those things happen. Management services can also include things like they're the ones that get all the emails from the owners when there's questions or maintenance requests, emergencies. They're the ones that request and compile bids from vendors when you're trying to get a particular piece of work handled within the community. They might even be advising the board about statutory changes and requirements and saying, hey, this thing is changing January 1, 2026. Maybe you should consult your association attorney to see if your documents need updating. Sometimes they will attend your board meetings. Sometimes they will take minutes at your board meetings. So that's something that you might not have to do. So the management services that are available to community associations are as limited as financial only and as broad as full service management with everything that I just talked about. And only you as a board in your particular community can understand sort of the cost benefit analysis of how much to farm out to a management company that can support the board when it comes to the day-to-day managing of the community, and what that cost will look like for your association and the owners within the community. Jen, did you have anything to add to that one?
No, I think you covered it. So our next question is really simple. Can a condominium association with more than 50 units vote to waive the audit required by the Condominium Act? So just briefly, the original question was too specific to answer. Please seek legal advice for your particular situation. But the answer to this question is no. The statute is 6434-372 sub 1. Specific language is shall be audited at least annually. But WUCIOA, when that comes into effect, changes the threshold to $50,000 per year of your budget, regardless of number of units. So if you are a condominium with more than 50 units and you're under 6434 or 6432, you are required to have an annual audit. You cannot waive it by vote of the ownership. Excuse me, that can change but it's honestly unlikely if you have more than 50 units that your budget will be under 50,000, but that could change once WUCIOA comes into effect. Valerie, did you have anything to add?
I do not. And I think if it's okay with you, since the next few questions were things that we put in to discuss, I'm going to jump to the questions from the chat, see if we can peck off a couple of those. The first one is, are there new WUCIOA restrictions on back billing assessments after ratification? So I'm going to just clarify to make sure I understand this question, which is, does WUCIOA restrict your ability to retroactively increase the assessments, essentially, if you don't ratify until, like, let's say you want to raise the dues on January 1, but your ratification meeting doesn't happen until March 10th or something. There isn't a WUCIOA restriction or a new WUCIOA restriction on that. However, you can't enforce increased assessments until you have a ratified budget. So if that is the timeline, that scenario is essentially what you're asking about, and you can tell me if I'm getting the question wrong in the chat. If that's the scenario you're talking about, what I would recommend and what I tell my clients to do is, in the budget ratification packet, make it clear that this budget is based on 12 months of assessments at this increased amount. Because we're not ratifying until early March, on April 1, there will be an added charge for everybody that makes up the difference between the 2024 assessments for January and February and the 2025, like, should have been assessments that we just didn't get ratified in time. So just disclose it is all I'm saying. If your budget ratification packet discloses it, then you make up for that gap between what the assessments were in the previous year and what you wish they had been for January and February of this year. Disclose that, charge the owners for the gap once the budget is ratified. Jen, did you want to add anything to that?
Just briefly, if you're trying to back bill, as Valerie explained, the date that assessment is due must be in the budget ratification packet. Otherwise, it's not collectible if an owner fails or refuses to pay.
Okay, next question. What is the recommendation for increasing fees for amenity rentals such as cabanas? Do you want to take a stab at that one, Jen, or do you want me to do it?
I can take a stab. There's no statutory guidance for this, but any fee tacked on to onto an owner's account must be reasonable. If you have, say, a cleaning fee, your cleaning service takes 2 hours, that fee is X. That can probably be passed on to an individual unit owner when they rent the cabana. But if you're using this as an income stream, those fees are likely not reasonable and probably won't be collectible if an owner fails or refuses to pay. Valerie, did you have anything to add?
Nope, I think that's great. And I think just like what I was saying with the assessment thing, so I guess I do have something to add. Notice, to give the owners notice. So if you're changing your fee schedule generally for the community, have the board adopt the updated fee schedule and send it out to the ownership so that it's not a surprise when somebody comes to rent the cabana and it's twice the amount that it was the last time they did it. Let's see, 10:59. I don't think we have time for an actual whole nother question. We've got less than a minute left. So I think we need to call it for today. If you submitted a question and we did not get to it this week, if it was something you submitted in advance, we will have it for next week. But if you put it in the chat and we didn't get to it today, please email it to info@condolaw.net and we'll get it on our list for next week. Thank you all for joining us and we'll see you guys then. Bye, everybody.